7th Judicial Circuit in and for Volusia County, Florida. Case number 91-257. State of Florida versus Aileen Carol Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grady, also known as Candy Marsh Green. As to count one, a majority of the jury, by a vote of 12-0, advise and recommend to the court that it impose the death penalty upon Aileen Carol Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grady, also known as Candy Marsh Green, dated at DeLand, Volusia County, Florida, this 30th day of January, 1992. Pamela J. Mills, foreperson.
Ladies and gentlemen of the jury, we're going to ask each of you individually concerning the advisory sentence. It is not necessary that you state how you personally voted or how any other person voted, but only if the advisory sentence is read was correctly stated. Madam Clerk, will you please vote?
Yes, sir. Do you, Mrs. Staten, agree and confirm that the majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Farrell, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mills, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. DeGainer, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mathis, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mrs. Walters, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes, I do.
Do you, Mrs. Wiley, agree and confirm the majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Flowers, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mrs. Bogan, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Watley, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Oransky, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Bashal, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Thank you all.
Any further requests of your charge?
Nothing by the state, Your Honor. Thank you.
No, Judge, thank you.
Ladies and gentlemen, I want to express to you and thank you very much for your time and consideration for this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that juries' deliberations, their discussions, and their votes should remain their private affairs so long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to them. A request may come from those who are simply curious or may seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. With those instructions, the jury is in recess and discharged for further obligation and responsibility herein. Sentencing is scheduled for 9:30 a.m. tomorrow morning. Mr. Pettit, if you'll escort the jury out of the room.
Judge, before you leave, we would renew all previous applications and motions and objections. Thank you, Judge.
The order that are here about that time.
Thank you, Your Honor.
Third report in the 7th Judicial Circuit is now in session. The Honorable Judge Uriel Blunt Jr. presiding. Please be seated. Quiet in the courtroom.
Docket number 91-257, the State of Florida versus Aileen Carol Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grody, also known as Candy Marsh Green. The court is prepared for sentencing. Does the state have any witnesses like to present at this time?
Your Honor, we have no witnesses. May I make a brief statement?
Yes, sir.
Your Honor, I'm not going to insult the intelligence or the wisdom or the perception of this court by going into any type of a detailed recounting of the facts and circumstances which brings Aileen Wuornos before this court at this time in this county. I would like to discuss just for a moment or two a couple of aspects of the law and why, in fact, the state is urging the ultimate penalty permissible under Florida's law for Ms. Wuornos. First, I say to you sincerely that this is probably, for every prosecutor, the most difficult assignment that our office faces, and that is the studied and considered decision to first ask the citizens and then ask the jurist to permit the law which requires the forfeiture of a human life to be activated against another citizen. It is not only of great and considerable legal weight, but I can tell you from a personal standpoint, and I speak for my staff, it is a great emotional drain upon all of us involved in a case like this. Nonetheless, the people of the state of Florida, through their elected representatives and through well-documented and voiced opinion polls over the years, as the people of this nation, believe that there is a place in our society, a necessary place in our criminal jurisprudence for the death penalty. Rare are the cases of murder on the grand scheme of the number of murders committed nationwide in which the death penalty can be fully and unequivocally justified. This is one of those cases. The aggravating circumstances, I'll not recount them. They were argued and the court instructed upon them, have been proven, Your Honor, beyond and to the exclusion of any reasonable doubt. The unanimous verdict of this trial jury, and I can say this, that they took the time to deliberate and return a unanimous verdict, which I think is a clear indication of the completeness of the evidence and the propriety of the sentence of death. I would ask you to not only sentence Aileen Wuornos to be electrocuted, I would ask that with regard to the additional sentences that the maximum penalty be imposed. We know that under the law, the 3-year minimum mandatory as a part of the robbery sentence is called for by statute. No exception for that, even in a murder case where a weapon is used, and I refer specifically to Chapter 775. Under the case law, and I cite Williams v. State, and I have a copy we've provided already to defense counsel, Your Honor, the imposition of the minimum mandatory is appropriate, and that is at 517 Southern 2nd, 681, Florida Supreme Court, 1988. Also,
Even if the weapon was a part of the statute?
we believe that is correct, Your Honor, under the Williams decision. May I into that case? Defense counsel has already been provided these cases. In addition, we're asking you to depart from what the sentencing guidelines which I believe has been one of the greatest impediments in the state of Florida to the fair and appropriate administration of criminal justice, and has directly resulted in the diminution of the respect for the bench and for the law in this state. Nonetheless, we are still bound by them, and we, and certainly like yourself, Your Honor, will abide by sentencing guidelines so long as they remain a part of our law. But a departure is appropriate in this case from what the guideline sentence would permit to a sentence of what the statute would allow, and that is life imprisonment. And for the authority of that, I would refer, Your Honor, to the state case of Hansbrough v. State, 509 Southern 2nd, 1018, as cited in Rutherford v. State at 545 Southern 2nd, 853. And if I may also provide the court with that case. Case essentially indicates that the forms that the legislature and committees developed under the sentencing guidelines provisions of the law simply don't include a category for a conviction of murder in the first degree to be considered at the time. And under the cases cited, the Supreme Court has upheld, in effect sanctioned, the departure for a sentence exceeding the guidelines up to the maximum statutory allowable. Also, if Your Honor please, with regard to the legalities of where we are for a moment, we would ask you to retain jurisdiction in this case for several matters. One, count 3 was severed at the bench just as the jury selection began. We would ask you to retain jurisdiction until count 3 is disposed of. There may come a time that discussions between ourselves and the defense will result in a resolution without litigation. We certainly hope that. We can only offer what we believe would be a fair resolution. We will do that at some time in the future. In addition, the state of Florida and the people of Volusia County particularly are entitled to reasonable and full cost assessment. We have not yet had an opportunity to compile those figures in their entirety. The bills from the mental health care experts have not been submitted. Bills for expedited depositions that became necessary because of the lateness of some of the experts' testimony, including their refusal to honor subpoenas from this court, resulted in many late-hour depositions and expedited printings of depositions. So we cannot come to you with those figures at this time. I'd ask you to retain jurisdiction for that. And in connection with that, the rule to show cause motions which have been filed, which we don't want to argue or present at this time, with regard to Dr. Elizabeth McMahon and Dr. Jethro Toomer for their refusals to comply with subpoena. Not meant as a vindictive measure, Your Honor, but only to hopefully bring an orderly procedure to cases in the future where we deal with that particular profession, and more specifically, those particular professionals. The housekeeping matters behind, I would only say in closing, this is the only time that I've stood before this particular jurist and asked you to enforce, uphold, and pronounce a sentence to take another person's life. I don't do it lightly. I can tell you I do it with a heavy heart. Aileen Wuornos has come into this courtroom with an utter disregard, continuing for the truth, with an utter disregard for the destruction she has wrought upon her victims, the continuing utter disregard for even the reputation of her very family, her deceased mother and father. Her acts of murder and of total, absolute, unwavering determination to avoid and deny responsibility continue even to this date. I ask you to sentence her to die in Florida's electric chair.
Mr. Tanner, do you have a guidelines worksheet for me?
Yes, sir. These two. Yes, Your Honor, I do.
Has a copy been made available to council?
That's what I was asking. Has the council copy been made? Your Honor. May we step out and make a copy?
Sir.
I apologize.
Well, let them view that one, then we can follow it.
That copy is-
Ms. Wuornos, when I have completed my task here today, you will begin the first day of the rest of your life. The curtain will fall on the tragic drama of the trial of Aileen Wuornos. Tomorrow's sunrise will bring the beginning of the appellate procedures as provided by law, and I will return to pasture. You have been convicted by a jury of your peers of the offense of first-degree premeditated and first-degree felony murder and armed robbery of a firearm of Richard Mallory. Do you or your attorneys who stand to your side have any legal cause to show why the sentence of law should not now be imposed upon you? Do you have any matters in bar preclusion sentence? Do you have any matters in mitigation of sentence that you would give the court at this time?
We have certain matters we'd like to bring up, Your Honor.
Yes, sir.
First, we would ask that Your Honor hear from Miss Aileen Fraley.
Certainly. So the court reporter can hear you, will you speak loudly enough and also give her your name?
Yes, my name is Aileen Fraley, P-R-A-L-L-E.
Your Honor, I'm sorry. I was going to say Ms. Fraley has certain matters that she would like to relate to the court. I mean, this is your opportunity to speak.
Certainly.
Okay, Your Honor, my husband and I adopted Aileen Wuornos on November the 6th. We heard in this courtroom 3 expert witnesses in the field of psychology who said that Aileen Wuornos, though 35 years physically, was emotionally and psychologically a child. Dr. McMahon referred to her as the most primitive one she had ever seen other than within an institution. My husband and I have spent as much time, if not more, than all of our experts combined. We are 100% behind their diagnosis, and I would plead for mercy for my daughter's life because she never was given the chance to grow up. She is still a child, as they have said, and there are 2 factors I think that are very important. Her school records indicated, as well as the experts, that Aileen Wuornos, from a very young age, wanted the structure of a very tight family. She longed to have that, a nurturing environment. And the school records also indicated that she was in need immediately of counseling, immediate. Those were never granted. Both of those factors are now present this day in 1992. She has a family that cares about her, that loves her unconditionally, and we are also, Your Honor, if you would give mercy, in this case, we are willing to pay for the professional counseling that Aileen Wuornos should have received as a child, and I just plead for your mercy for my daughter's life.
Thank you very much, ma'am. You may return to your seat.
Judge, as to the show, a couple of technical matters. As to the show cause issue that Mr. Tanner mentioned, we would like an opportunity to be heard on that.
You shall.
I take it today is not the appropriate time.
I think not.
Yes, Judge. As to the proceedings as a whole, we renew our previous motions, objections, and applications. We do have certain brief comments, and I think Ms. Wuornos has certain brief comments as well. You want to go first?
Yes. Okay. First of all, I'd like to say that I have been labeled a serial killer, and I am no serial killer. I've been framed by the law enforcement as a serial killer because of numerous men involved. But what I was a prostitute. And in my prostitution, I happened to deal with a lot of men, at least 200, 250 men a month. And I ran into these men along the way in my prostitution. I do not feel, I was not out there to hurt anyone. I had no intentions of hurting anyone. In my confessions, I stated that 9 times. I stated 37 times self-defense, 39 times that they raped or beat and then begin to rape and had intentions of killing. And what I did was what anybody else would do. I defended myself, which everybody has the right to defend themselves. And I had no intentions of killing anyone. I would not do that. I'm not that type of person. Anyway, what I'm trying to say here is that while I've been through this 2.5 weeks in the courtroom, I told you that I was raped, and that is what happened. And that is what happened with all other cases that I'll be involved in and discussing. And these people did a violent attack on me, and I did what I had to do to protect myself. Now, I'd like to point out one other thing, is that the law enforcement has framed me as serial killer purposely for books and movies. And I have been, since I've been incarcerated a year in jail, have gone through a lot of physical and mental abuse, which I felt is being a conspiracy through the law enforcement. And I also believe the law enforcement and the state attorneys have a conspiracy here. And I have to say another thing, for as far as manipulation was talked about yesterday in the courtroom, I believe State Attorney Tanner was the one manipulating the jury, which he had made a whole lot of things up. Things were just made up at the top of his head, were not true, and I felt that he lied right through his teeth. I was up in that stand there, and I did not lie. I was coerced into making my confessions. I was threatened that Tyra Moore would be arrested if I did not talk about the confessions. I was also coerced and threatened and told that if I did not answer their questions the way they wanted me to, their questions, and I did it any other way, that she would be arrested. And the questions that they asked me were strictly to implicate me as a serial killer, when every time I talked about a rape, they cut me off, and they had my mind all messed up, where I was hysterical, I was in trauma, and I was alcohol withdrawing. I have been totally under duress and delirium, and I couldn't tell you what happened anyway. I couldn't remember anything under that stress. All I had in my mind was focused on Tyra, which I was trying to clear Tyra, which Tyra knows it's self-defense, and she's lying through her teeth, telling that she doesn't know anything, even the smallest of things of our life together, 4.5 years, and she does know. She knows it's self-defense, and she's been offered like $500,000 and might be a multimillionaire after this is over, and she's just keeping her mouth shut because she wants money. They have to have a conviction in order to get this money. And that's all I got to say. I'm not a serial killer.
Your Honor, we have some observations. I guess I should go first. Or maybe I could make some observations for the three of us. Mr. Tanner provided to Your Honor some personal views as to his understanding of his position here and the difficulty that he has, and I think that's legitimate. I really do think Mr. Tanner finds this role very difficult. Hasn't been easy for us either. It has been a difficult task when you're litigating over the life of a fellow human being. What I would suggest to Your Honor, and we will not go through aggravators and mitigators and rehash the evidence. Your Honor has heard it, and like Mr.
I need to speak again, okay?
Yes, ma'am, you
Okay,
may.
oh, okay.
You want to wait till he's
Yeah.
through, or you want to talk
I didn't know.
now?
I just wanted to make sure he wouldn't cut me
Go
off.
ahead now.
Okay. What I'd like to also say is that we had 2 clients that were willing to testify for me, that we did not bring the mitigator factors in, and I was surprised that my lawyers had me just testify on the stand and then said, the defense rests this case, because I did not know this was going to happen. We had a police officer that was going to verify that they misused evidence and that they falsified reports. None of the evidence, all the evidence on the floor, there was half of the stuff was mine. And there was a radio on the floor that one of the victim's family said, yeah, that's mine, and it isn't. It was our radio, and Tyra knows that. And I'm sure I could get a witness to verify that radio I had before Richard Mallory was ever killed. And I kept all the weapons in storage. None of the weapons were on the floor for proof, if I ever got busted, that I could prove that these guys used these weapons on me. None of the weapons were on for evidence. And we had 2 clients. We had a police officer. There was also, I had high school friends, at least 15, that I wanted contacted. They were not contacted. This case did not, for me to testify for myself, it seemed like I got a total raw deal. I should have had, my clients should have went up. That officer should have went up. I should have had my high school friends testifying for me. I couldn't believe I just got in that stand for myself. And I was telling the complete truth. I was being as honest as I could be.
Thank you. Mr. Nolis, you may proceed.
Yes, Your Honor. What I was going to say is just to give to Your Honor some personal observations.
Certainly.
Your Honor has a very difficult job here. You've been on the bench quite a long time, and you've seen, I dare say, quite a lot more than the 3 of us combined. It is a task that we do not envy, and that hopefully none of us will ever be in the position to make. I know I never want to be in the position to make the type of decision Your Honor needs to make here. We, as a people, can decide to impose the death sentence on Ms. Wuornos. We can decide to have her executed. Those procedures, as Your Honor know, are about as cold and calculated and premeditated, and using those terms, as any procedures can get. It's done with a great deal of formality, with a great deal of calculation. What I would suggest to Your Honor is that such a sentence would meet none of the goals that we consider to be penologically appropriate. No one would be deterred by a death sentence on Ms. Wuornos. Surely rehabilitation is not at issue. And the only question is really retribution. And the question is it worth the thousands and millions of dollars that it's going to take to have Lee Wuornos executed? Is it worth us as a society? Is it something we should do? We can do that. If we were to do that, we will be doing something, and I would submit to Your Honor that we will be accomplishing nothing. And with that, Your Honor, I guess
Ms. Jenkins, Mr. Miller.
I have nothing to say, Your Honor.
All right, the defendant, Aileen Carol Wuornos, being before the court, attended by attorney Tricia Jenkins, William Miller, and Billy Nolis, her attorney of record, having been tried and found guilty of crime count 1 of first-degree premeditated murder and first-degree felony murder of Richard Mallory, a capital felony, and count 2 armed robbery of a firearm, armed robbery of Richard Mallory with a firearm, and no cause being shown why the defendant should not be adjudicated guilty, you're hereby adjudged guilty of said offenses. You will be, as required by law, compelled to pay $20 to Crimes Compensation Trust Fund and $5 in accordance with Florida Statute 943.25, subparagraph 4. I've reviewed your affidavit of indigency, find that you're unable to pay costs, and accordingly all costs are hereby waived. As to count 2, the sentence is imposed in accordance with the guidelines mandated upon this court by the state of Florida. The defendant being before the court attended by her attorneys Tricia Jenkins, William Miller, and Billy Nolas, having been adjudicated guilty herein, and the court having given you an opportunity to be heard and offer matters of mitigation of sentence, no cause being shown. The sentence of the law and the judgment of this court that you, Aileen Carol Wuornos, be imprisoned by confinement and committed to custody of the Department of Corrections for a term of 10 years from this date, with credit for times heretofore served in the Volusia County Jail. And you will be compelled to serve a 3-year mandatory minimum as provided by Florida Statute 775.0872. That's in count 2. As to count 1, you will be required to make restitution as entered by a separate order that I am signing at this time. As to count 1, the defendant Carol Wuornos being now before the court attended by her attorneys Tricia Jenkins, William Miller, and Billy Nolas, and having been adjudicated guilty of the crime of first-degree premeditated murder and first-degree felony murder, a capital felony, and the court having given the defendant an opportunity to be heard and to offer matters of mitigation of sentence and to show cause why the sentence of law should not now be imposed upon you, and no cause being shown, I'm filing with the clerk my written findings in this matter. Copies will be made available to the council when they're available. It is the sentence of the law and the judgment of this court that you, Aileen Carol Wuornos, be delivered by the sheriff of Volusia County, Florida, with a copy of this sentence forthwith to the proper officers of the Department of Corrections of the state of Florida, and by him safely kept until by warrant of the governor of the state of Florida, you, Aileen Carol Wuornos, be electrocuted until you are dead. And may God have mercy upon your court. The judgments and sentences will be entered in open court this 31st day of January 1992, and my signature attached. The court does now advise you that you have the right to appeal the judgment and sentence imposed upon you, and upon showing to the court of your desire to appeal the judgment and sentence, and should you be an indigent person, counsel will be appointed to represent you for the appeal purposes. Will you please step over to the bailiff for fingerprinting, ma'am?
This way, Aileen.